Everybody, Rich with Prep U hanging out at my desk outside the bunker. So, yep, federal judge blocks Illinois gun and magazine ban while other cases continue. All right, so this is the case with Judge Stephen McGlynn out of East St. Louis in regards to asking for an injunction uh, in one of the cases. Now, remember, this is the case that I say case, but it's cases because they were put together. Okay, and basically got this information one from an article from the Center Square. I tell you all the time, please go to the Center Square, sign up for their daily news dumps, and you'll be very happy for that. Basically, they said Illinois gun and magazine ban is on hold after a federal judge in the Southern District of Illinois ruled in favor of a preliminary injunction. And they also state that this case could be appealed to the Seventh Circuit Court of Appeals, where another challenge is pending. So basically, on Friday, Judge McGlynn granted a motion for a preliminary injunction blocking enforcement of the law statewide. Because if you remember, it was kind of piecemealed before. Some of the other state judges just allowed the plaintiffs to have an injunction for them against that law. Basically, in a synopsis of this, McGlynn wrote, "The plaintiffs have satisfied their burden for a preliminary injunction. They have shown irreparable harm with no adequate remedy at law, a reasonable likelihood of success on the merits, that the public interest is in favor of the relief, and the balance of harm weighs in their favor. Therefore, the plaintiffs' motion for preliminary injunction are granted. Defendants are enjoined from enforcing Illinois Statute 720 ILCS 5-24 or /24-1.9 B and C and 720 ILCS 5/24-1.10, along with the PICA amendment provided set forth in 735 ILCS, subparagraphs 11, 14, 15, and 16, statewide during the pendency of this litigation until the court can address the merits." Okay, so what does it look like? Well, the memorandum in order kind of looks like this. This is double-sided, and it came out to a total of 29 pages. All right, I want to go through this a little bit, and a couple of reasons I want to go through this is it gives you a better understanding of the case set forth by the plaintiffs. All right, and the plaintiffs are Kay Barnett, Dane Harrell, Jeremy W. Langley, Federal Firearm Licensees of Illinois, and those are the main ones in this case. And the defendants are Kwame Raoul, Brendan Kelly, and J. Robert J.B. Pritzker. But I want to kind of show you where the cases are and how thought out these cases are or aren't, and what the judge used, different cases that the judge used to come to his decision, and where those decisions that he made based on to get to the injunction will go forward probably all the way to the Supreme Court. So the next level is very interesting, and we'll discuss that after I get done with this. So this is not going to be an entirety. I'm not going to read the whole thing. You guys will be, and gals will be snoring, through a lot of this. But it's not as bad as the original law. A lot of this is very pertinent. So I'm just going to hit the highlights of this for you. So like I said, it's 29 pages. It starts out with memorandum and order. District Judge McGlynn. Before the court are consolidated cases with the request for the imposition of a preliminary injunction under Federal Rule of Civil Procedure 65A to prevent the enforcement of Illinois Protect Illinois Communities Act, or PICA, until there can be a final determination of the merits as to the law of the constitutionality. So his job was to look at this as if he was going to put it on hold or let it stay enforced until the final judgment. And I think we all know where it's going to end up is the Supreme Court. And he kind of goes into the whole thing that back on June 23rd, 2020, United States Supreme Court issued its opinion in New York State Rifle and Pistol Association Incorporated versus Bruin. Amongst other things, the Bruin court reaffirmed that the right to bear arms refers to the right to wear, bear, or carry upon the person or in the clothing or in the pocket for the purpose of being armed and ready for offensive or defensive action in case of conflict with another person. So so right off the bat, he's citing the Illinois State Rifle Association versus Bruin case, which is really cool. He then goes on to talk about 2 weeks later was the horrible Highland Park shooting, massacre, basically. And then talks about some months after that, the state of Illinois enacted PICA. But what he says is, more specifically, can PICA be harmonized with the Second Amendment of the United States Constitution and with Bruin? That is the issue before the court. The simple answer at this stage in the proceedings is likely no. The Supreme Court in Bruin and Heller held that citizens have a constitutional right to own and possess firearms and may use them for self-defense. PICA seems to be written in spite of a clear directives in Bruin and Heller, not in conformity with them. Good point. So what he's saying is there's a definite difference between higher court rulings and this law. And that's where he's stepping in, and that's where he's going to figure out the injunction. So this goes into jurisdiction and venue, standing. Then it goes into facial challenges and severability. So he goes into, because this court finds a likelihood of facial unconstitutionality on the merits, the entire PICA as coded will be enjoined. So right there, he's telling you, all right? It is important to note that the court has not found that PICA or any provision is in fact unconstitutional, only that the likelihood that it will be. So basically the plaintiffs and their attorneys brought forth enough information to say to him, whoa, I can't make a final judgment on this. My job is to decide whether an injunction is warranted. Higher courts will decide if it's unconstitutional or not, but he found that there was enough data brought forward that he feels that there is a reason for it to be enjoined statewide. All right. So legal standings and injunctive relief. A preliminary injunction is an extraordinary and drastic remedy for which there must be clear showing that plaintiffs is entitled to relief. The purpose of a preliminary injunction is to preserve a party's position until a trial on the merits can be held. The issuance of a preliminary injunction should also minimize the hardship a party's pending final judgment. So, in that case, he's talking about, he'll say it later, about individuals not being able to buy said firearms for personal protection. Stores not being able to sell said firearms for monetary gain. And they're also having these items sit in storage where they're losing money on them and paying taxes on it. Then he goes into the analysis of requests for injunctive relief. And then he talks about phase one, irreparable harm. We'll talk about that. Then he brings up, not only does he bring up Bruin, he brings up McDonald versus City of Chicago. And he called it a plurality opinion. When a law is facially challenged under the Second Amendment, the form of the claim and the substance of the Second Amendment create a harm that is properly regarded as irreparable and having no adequate remedy by law, which means there's no remedy by law except to get rid of the law that caused the harm. All right. So I'm trying to go through this really quick. Okay, so then he goes into no adequate remedy by law, and here he cites a whole bunch of other attempts, but then he says, but for PICA, Barnett and Norman, who were two of the plaintiffs, would purchase additional banned firearms and magazines. Should either one attempt to do so, he could face criminal penalties. There is no monetary award that can be compensated for such injury or make them whole. And he also says, and both Hoods and pro-gun have lost income and will continue to do so while PICA remains in effect. All right. Then he goes into the likelihood of success on the merits. This is a judge speaking. This court must now consider a third issue, likelihood of success of the merits. Plaintiffs rely on recent Supreme Court decision that made it clear that the Second Amendment protects the possession and use of weapons that are in common use. And he'll explain here a little bit later why he considers these firearms that they have found to be illegal in PICA are really in common use. Then he goes into what the whole Second Amendment talks about and what it means. Now he cites Heller again, also United States versus Sprague, and the meaning of the Second Amendment. All right. In Heller, the court broke the operative clause down further into two sections, right of the people and keep and bear arms. Court noted that the right of the people is only used 3 times in the amendments in the First, the Fourth Amendment, and most recently to this case, the Second Amendment. So there, he states, there is a strong presumption that the Second Amendment right is exercised individually and belongs to all Americans. And what he's talking about there now, if you think about it, one of the things that the plaintiffs brought up is that some people weren't covered by PICA, but some people were. Okay, so now he's saying belongs to all Americans. The second section of the operative clause, keep and bear arms, defines the substance of the right held by people. The Heller court first turned to what constitutes arms and found that arms were understood near the time of the ratification of the Second Amendment to mean any weapon or thing that could be used for either offense or defense. The court specifically noted that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of founding. And that was something that the defendants stated with PICA in their case, is that, wait a second, these firearms weren't, even thought of back in the time, and the judge just kind of blew that out of the case. And finally, the court turned to the meaning of keep and bear arms. In light of founding era history, to mean to have and to carry respectively. In sum, the operative clause of the Second Amendment guarantees the individual right to possess and carry weapons in case of confrontation. And then he goes on back to McDonald about due process and the fundamental to our scheme of orderly liberty. Consequently, the court held that due process clause of the 14th Amendment incorporates the Second Amendment. And finally, this court turns to Brune. In analysis, the constitutional question presented in Brune court first turned to its prior holdings in Heller and McDonald. The court held that the Second Amendment protects an individual, keeps right to bear arms. All right. And he explained that in the years following Heller and McDonald, the Court of Appeals analyzed the Second Amendment under a 2-step test. The first step included an analysis to determine if the original scope of the right based on its historical meaning. The second was a balancing test of either intermediate scrutiny or strict scrutiny depending on if a core Second Amendment right is burdened. But in the Brune case, writes the judge, the court firmly rejected a 2-step framework, concluded that despite the popularity of this 2-step approach, it is 1 step too many. The court instead adopted a single-step test rooted in the Second Amendment text, as informed by history, under which the government must affirmatively prove that a firearm regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. Under this framework, the Second Amendment protects the possession and use of weapons that are in common use at the time. Common use throughout history. All right. Let's see here. So stated in Heller, the full standard for the Second Amendment analysis is when the Second Amendment's plain text covers an individual's conduct, the Constitution presumably protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. And basically, by not going that, it's a violation of the Establishment Clause. Examples of this are when a challenge regulation addresses a general societal problem that has persisted since the 18th century, firearms, the lack of a distinctively similar historical regulation addressing that problem is relevant evidence that the challenge regulation is inconsistent with the Second Amendment. PICA is inconsistent with the Second Amendment. Likewise, if earlier generations addressed the societal problem, but did so through maternally different means, that could also be evident that a modern regulation is unconstitutional. The history, all right? So then he goes into what he calls plain text analysis, which is going between PICA, using Brune, and then he goes into the addressing the defendant's contention that non-essential accessories are not within the scope of the Second Amendment plain text. PICA outlaws possession of a semi-automatic pistol with a detachable magazine if it is equipped with any of the following: a threaded barrel, a shroud attached to the barrel or that partially or completely encircles the barrel, a flash suppressor, or an arm brace. All right. So defendants contend that the state are the defendants. Defendants contend that such items are not necessary to the functioning of a firearm and are thus not arms and therefore not protected by the Second Amendment. Per the judge, defendants' argument is not persuasive. The Seventh Circuit has recognized the Second Amendment as existing to corollaries to the meaningful exercise of the core right to possess firearms for self-defense. All right. The Third Circuit Court recognized the importance of this corollary and held that a magazine is an arm under the Second Amendment. Defendants' own experts defined high-capacity firearms as handheld arms with a capacity greater than 10 rounds. Defendant's expert is clearly referencing magazines and incorporating such into its definition of a firearm. This court agrees that magazines are arms as used in the plain text of the Second Amendment. So, wittingly or unwittingly, the defendant's attorney admitted that yes, based on the magazine and the regulations of magazines, they have to be with the firearm in order for that firearm to work. All right. So, if defendant's own expert incorporates magazine capacity into his definition of a firearm, given his level of expertise, it would be unreasonable to expect the ordinary public meaning of the plain text not to reflect a similar understanding. Defendants say it's part of the firearm, it's part of the firearm. All right. Seventh Circuit held in Easel that Chicago could not prohibit law-abiding citizens from target practice at a fire range because doing so interferes with the meaningful exercise of their Second Amendment right. PICA also interferes with the meaningful exercise of Second Amendment rights for one group of individuals, those with disabilities. Okay, and why does it affect those with disabilities? Because They talk about PICA prohibits the use of arm brace on semi-automatic pistols with a detachable magazine without any caveat or exception. The Department of Justice has also attempted to regulate possession and registration of arm braces. But stabilizing braces, one notable distinction exists. The Bureau of Alcohol, Tobacco, Firearms, and Explosive has recognized that such braces are necessary for those with disabilities to use a firearm by directing that this rule does not affect stabilizing braces that are objectively designed and intended as a stabilizing brace for the use by individuals with disabilities. All right. So by disallowing the arm braces and forward grips and stuff like that, it makes it hard for those with disabilities to actually protect themselves and to enjoy their Second Amendment rights. All right. So, as reason and the ATF final rule evidences, braces are needed by certain individuals with disabilities to operate a firearm. Thus, arm braces are an integral part of the meaningful exercise of the Second Amendment rights for such individuals and can also be considered an arm. Okay, so this next couple of pages, he goes into more examples and also more case law. Then he gets into the nation's historical tradition of firearm regulation. All right. This court must next determine if PICA is consistent with the nation's historical tradition of firearm regulation. Pursuant to Bruin, as outlined above, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. Therefore, to bear its burden, defendants must demonstrate that the arms PICA bans are not in common use, and two, identify a well-established and representative historical analog. All right, so what the judge then goes on to say is the defendants first argued that PICA is consistent with historical traditions because neither large capacity magazines nor assault weapons were in common use when the Second and 14th Amendment were ratified. This argument is bordering on philosophy, ridiculousness, because the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. That came out in Heller. Defendants also argued that the act restricts weapons and accessories not commonly used for self-defense today. Similarly, this argument is misplaced. In Bruin, it clearly holds that the Second Amendment protects possession and use of weapons in common use, not just weapons in common use for self-defense, as defendants argue. Even if there was a requirement that common use of an arm be self-defense, AR-style rifles would meet such a test, considering that 34.6% of owners utilize these rifles for self-defense outside of the home, and 61.9% utilize them for self-defense in the home. So, the judge is saying they are common firearms, but even at that, they are used primarily for outside the home and inside the home self-defense. Let's see, where are we going from here? We are going to, So, however, they're talking about the entirety of AR-15s and their commonality or lack thereof. And Judge Kavanaugh noted there is no meaningful or persuasive constitutional distinction between semi-automatic handguns and semi-automatic rifles in the Heller case. However, supposing that defendants need only to show that AR-15s are not in common use, they still fail. All right. Plaintiffs added that recent data shows that more than 24 million AR-15 style rifles are currently owned nationwide. So there's more firearms than Ford F-150 trucks sold. The most commonly sold vehicle in the United States, Ford F-150, so quotes the judge. And in Coble versus Hogan, 24 million firearms dwarf the 200,000 stun guns, which the Supreme Court found sufficient to meet the common use test. So there's your common use test. All right. So AR-style rifles are among the most popular arms produced, accounting for nearly half of all rifles produced in 2018 and nearly 20% of all firearms of any type sold in 2020. AR-style rifles possess no quasi-suspect character and traditionally have been widely accepted as lawful possessions. All right. Further, considering the commonality of magazines banned by PICA, which, as this court explained, are arms for the purpose of the Second Amendment, the analysis becomes even more clear. There are about 39 million individuals who have owned magazines that hold over 10 rounds, up to 542 million such magazines in total. 39 million individuals is over 3 times the population of Illinois, and it basically shows common use again. Both AR-style rifles and magazines with the capacity greater than 10 are in common use and protected by the Second Amendment, per the judge, basing his judgments off of the Bruin case. Although defendants challenged the veracity of plaintiff's evidence, they were unable to produce evidence showing that modern sporting rifles are both dangerous and unusual. Consequently, defendants failed to meet their burden to demonstrate that the arms banned in PICA are dangerous and unusual and thus not protected by the Second Amendment. All right. Let's see. Then it goes down to defendants relied on a litany of experts to support the proposition that a ban on assault rifles has sufficient historical analogies to pass constitutional muster. However, the relevant analysis of each historic firearm regulation must be centered around how and why the regulation burdened the Second Amendment. As defendant counsel noticed, the regulations cited by the defendant's experts were concealed carry regulations. That's what they were. They were largely concealed carry regulations. The how and why of a concealed carry regulation is categorically different than the how and why of a ban on possession and cannot pass constitutional muster as a historical analog to demonstrate this nation's historical tradition regarding an arms ban. All right, then he goes into phase 2 and the balancing of harm and the public interest. He cites several other cases. He says, there is no question that plaintiffs are harmed by PICA and will continue to be harmed if this court denies the motion for a preliminary injunction. A constitutional right is at stake. Some plaintiffs cannot purchase their firearms of choice, nor can they exercise the right to self-defense in the manner they choose. They are bound by the state's limitations. Moreover, plaintiffs cannot sell their inventory, even to residents of other states that do not ban the arms identified by PICA. To the contrary, there can be no harm to a government agency when it is prevented from enforcing an unconstitutional state. All right. Defendants will not be harmed by having to conform to constitutional standards, and without an injunction, plaintiffs will continue to be denied their constitutional rights. However, this does not end the inquiry. The court must also balance the severity of PICA against the core Second Amendment rights of armed self-defense with the public interest justification of protecting Illinois communities. It is sorry, I went too fast. That law-abiding members of society, including the elderly, infirm, and disabled, have a constitutional right to arm themselves for self-defense. The need for self-defense is not insignificant. According to a report by the Department of Justice, Bureau of Justice Statistics, household members are present for almost a third of all burglaries and become victims of violent crime in more than a quarter of those cases. Studies on the frequency of defensive firearm use in the United States have determined that there are up to 2.5 million instances each year in which civilians used firearms in home defense. Handguns, many of which are limited under PICA, are the most preferred firearm in the nation to keep and used for protection of one's home and family. It is also uncontroverted that many of the ban modifiers, including those but not limited to pistol grips, protruding grips, flash suppressors, and Strouds, have legitimate purposes that assist law-abiding citizens in their ability to defend themselves. The other side is less clear. There is no evidence as to how PICA will actually help Illinois communities. It is also not lost on this court that the Illinois Sheriff's Association and some Illinois state's attorneys believe PICA unconstitutional and cannot, in good conscience, enforce the law as written and honor their sworn oath to uphold the Constitution. In no way does this court minimize the damage caused when a firearm is used for an unlawful purpose. However, this court must be mindful of the rights guaranteed by the Constitution. Moreover, PICA did not just regulate the rights of people to defend themselves, it restricted that right, and in some cases completely obliterated that right by criminalizing the purchase and the sale of more than 190 arms. Furthermore, on January 1st, 2024, the right to merely possess these items will be further limited and restriction. Accordingly, the balance of harm favors the plaintiffs. And what he's talking about, we all know, January 1st, 2024, those of us that have modern sporting rifles have to be registered with the state. All right, conclusion. Plaintiffs have satisfied their burden for a preliminary injunction. They have shown irreparable harm with no adequate remedy at law and reasonable likelihood of success on their merits, and the public interest is in favor of the relief, and the balance of harm weighs in their favor. Therefore, plaintiffs' motion for preliminary injunction are granted. Defendants are enjoined from enforcing the Illinois statutes and along with PICA's amended provisions set forth in another, including subparagraphs 14, 15, 16, statewide during the pendency of this litigation until the court can address the merits. The court recognizes that the issues with which it is confronted are highly contentious and provoke strong emotions. Again, the court ruling today is not a final resolution of the merits of the case. Nothing in this order prevents the state from confronting firearm-related violence. There is a wide array of civil and criminal law that permits the commitment and prosecution of those who use or may use firearms to commit crimes. Law enforcement and prosecutors should take their obligations to enforce these laws seriously. Basically, he's saying enforce the laws that are on the books and be serious about it. Judges should exercise their prudent judgment in committing individuals that pose a threat to the public and imposing sentences that punish, not just lightly inconvenience, those guilty of firearm-related crimes. And that is so ordered, dated April 28th, 2023. Stephen P. McGlynn, U.S. District Judge. And that, in that last little statement, is a major slap in the face of all these Soros-backed DAs that are letting criminals right out. There's no cash bail. They're letting people out before the police even get done writing the reports and pleading down firearm-related crime. Just a slap right in their face. So that's it in a nutshell, okay? But going back to the article from Center Space, the Center Square. On Friday, let's see. Oh, we already read that part. Did I read that part? I don't know. Where's my last page? See, I do this all the time. I put stuff down and I don't know what I did with it. There we go. Ha, found it. We're not done yet. Messages to Pritzker's office and the office of the Illinois Attorney General Kwame Rule were not immediately returned. Okay. It is expected the state will appeal to the Seventh Circuit Court of Appeals, where the court has the case brought by law weapons owner Robert Beavis. Beavis sued Naperville last fall and amended his complaint to include a challenge to the state ban. In February, Northern District Judge Virginia Kendall ruled in favor of the state in Naperville and against the plaintiffs, saying that the state met the burden that the banned firearms are dangerous and can be banned under the history and tradition of how the U.S. regulates firearms. That's going to be interesting because this case is going to her, more than likely. All right. McGlynn saw things differently from Kendall, as he said, although defendants challenged the veracity of the plaintiff's evidence, they were unable to produce evidence showing that modern sporting rifles are both dangerous and unusual. Consequently, defendants failed to meet their burden to demonstrate that the arms banned by Protect Illinois Community Act are dangerous and unusual and thus not protected by the Second Amendment. So there you go. There is the why and how he came to his decision using case law, using Supreme Court case law and other cases. What I'm going to do is the judgment from the judge and this article, I am going to post as a URL. Okay. Hopefully I will. I've done this in the past. You know me, Mr. Technicality or technical guy. I'm going to post that in there so you can go to it and you can print it if you want to. You can take a look at the little particulars. There's a lot of legalese in here that I skipped. But basically, I think what the judge is saying is that the plaintiffs were correct. The defendants, it's an unconstitutional law. So, and I'm going to let you go from there and decide what you think about it. And we'll follow this case all the way to probably the Supreme Court. There's a whole bunch of other cases that are out there that will make their way that way. Also, we'll see which side the cookie crumbles on, or if you get heads and tails on the quarter. So that's it. Thank you for watching. I know it was a long video, but I hope that you picked up things along the way, and you are much more the wiser on this case and can say how well the plaintiff's attorneys worked this case using case law and their ability to prove that the Second Amendment, along with the 14th, are extremely important, and we need to keep them free and clear, as the Second Amendment even states. So thanks a lot, subscribers. Thank you for subscribing. Hopefully we'll get more subscribers, and please pass this along to anybody you know that would be interested. So as we always say, always be aware of your surroundings. Please have food, water, medicine, ammunition, enough on hand to shelter in place for upwards of God knows how long, and at least 3 to 6 days if you have to bug out. And please prep like your life depends on it, because it really does. Thanks a lot. Take care. See you in the next time they come up with another court case on this.